Good morning. My name is Phillip Jaffe, and today I'm going to talk to you what to do if you get served with a summons and complaint regarding some credit card debt. For example, if you've gotten something like this is a summons and complaint, and it has a lot of things in here, and a lot of things in here tend to be very incorrect, and there are many ways you can fight it. But the one thing I will tell you, you must always answer a summons and complaint, because if you don't, the attorney will go to court and he will say that you didn't answer it and get a default judgment. Now, maybe 90% of the cases in court when attorneys sue are default judgments. So let's step back a little bit and see what exactly happens. Originally, you may have signed something with a creditor, and therefore when you haven't paid it, after a period of time, he may write off part of it or all of it. But meanwhile, he sells to a debt collector who will try to still collect on everything even though he's not supposed to. So what you want to do is you want to put certain defenses in, and you want to do within 20 or 30 days, because 20 days if you've been served directly, or 30 days if you receive the summons and complaint by mail. Now, for example, when they serve you with this, they many times have what they call a verification. The attorney has read this, he knows all the facts in here, and all you have to do now is, all they have to do is collect the money from you. Well, that's absolutely untrue, because near 100% of the time, the attorneys never read this, but they go into court with fraudulent documents saying they have read this, and the court, because you're not there, will say, well, it's a judgment for the creditor. So you always want to answer these things. So, but it's very easy to answer these things. You just write there that, number one, many times you don't owe the debt, so you write you don't owe it. And secondly, you want to see how they received it. In other words, these people receive, maybe some law firms receive 5,000 of these things a week, and they only have maybe like 14 attorneys. So do you think they can actually read all these things? No, they can't. So what happens is that if you put a defense in that you want to see the assignment and you want to see all the documents, many times the attorney will just drop your case then, and you won't have anything to do. But you know, you have to be careful. They can attach your bank accounts, they can attach your job salaries, they can do a lot of things if you don't answer. So it's always very important to answer these things. They always look scary, so they're not as scary as they look, because what you just have to do is make sure that you answer it in time and get everything to the court as soon as you can. And this is just a regular legal process here, and you want to be part of the legal process. There's nothing wrong with putting an answer in. So if you think you owe the money, you may not owe the money. They may have done other things. They may have put interest on there. They may have done a lot of other things. And savvy judges know what they're looking for. And not only that, but every court has a pro se division. So if you don't know what you're doing, go to the court a couple of days after you get this, and they'll tell you what to do. And they'll tell you how to answer it. But if you have any questions, I'm here. My name is Phillip Jaffe. You can also reach me at Phillip Jaffe Lawfirm.com. I'm on the web, and I'd be very happy to speak to you about anything, or if you have any question about doing it yourself. Again, it was nice speaking to you today. I have other videos that you may want to see: how to open default judgments, bankruptcy, auto accidents, slips and fall. So, please see me on the web, but you always can call me. Thank you very much again.